morning.
Please sit down. How are you?
I'm well in yourself.
Fine, thanks. I've looked through the documentation that you let me have, and before we start anything, I need to let you know that we may face a little bit of a problem here. I think that there may be a conflict of interest in this case.
In this case?
Yes.
But I don't know you.
To explain that to you, a conflict of interest is a situation where you seek legal representation, but the representation given, so for example, the representation that you're seeking from me may impact your case negatively due to a relationship that I have with anyone related to this matter.
Do you have family members? You've stated that there's a conflict of interest, but I don't know how it applies to this case. How is there a conflict of interest here?
So after going through all your documents and doing the necessary research, it came to my attention that one of your creditors was actually a close friend of mine. So it puts me in a very awkward situation, because you're really close. He might also come to me for advice on a personal sort of basis, and I wouldn't want to compromise your case like that. What more must
I understand what you're saying, but I trust you have seen your work, and you've had good results. So I doubt that you would be biased in any way.
So in the legal profession, we all have to uphold a certain level of ethics, and included in that is that I should notify you when such a situation prevails. So this is for your best interest, so that you're not compromised.
Okay.
So I fully understand the implications regarding the issue at hand. So thank you for your kind advice.
Yeah. And to add from what my colleague was saying, Mr. Jones, it is important also to note that if in a hypothetical situation it would happen that you guys would be liquidated, then our conduct would be looked at in that instance, and if it is found that we would acted improperly by representing you and representing the other person whom we already have represented, we already have knowledge of his affairs and also have knowledge of your affairs. That's putting us in a compromising situation, and not in that case refusing or declining representing you, then would be in trouble in that case. So it would also put us in a dangerous position legally if we were to proceed to represent you. So that is why we see it not advisable to accept representing you in this instance.
And there is various case laws supporting this.
Ma'am, I understand that you said you really can't represent me, hence there's a conflict of interest. So would you kindly explain to me this issue of conflict of interest and address me on the law specifically? Which law addresses the issue of conflict of interest?
Well, because of our personal nature, the relationship that we have with the other client, in terms of the Companies Act, we're required to treat all creditors equally and with transparency and fairness. And in that aspect, for example, if we were to act on your behalf and in the liquidation process, there could be undue influence. For example, you could ask for a reduction in fees or a removal of certain fees, or you could ask for example, a undue influence in terms of a bribe or so forth. So our role is to be as impartial as possible and objectively. Also, in addition to that, we are required in terms of our code of ethics as a society and as an association to not act with any fear or favor. So it would actually be to your detriment if we were to represent two creditors to whom we have either a direct or indirect personal relationship with the other.
Understood.
I think my colleague can explain.